Hello, good citizens. My name is Dan, and welcome back to Documenting and Exposing West Shore RCMP. This is part 14. So in the last two parts, I covered an application hearing on August 15th, 2019. So for this part, there was another court hearing approximately 20 days after that. This court hearing is September 5th, 2019. And this court appearance, we are before Judge Lisa Mrozinski. So one thing about this judge in this transcript is she says, okay, about 10,000 times. So I've decided to leave, every time she says, okay, I've decided to leave that out every time in the audio version of this update video. If I added every okay, she says, it would probably take me another 3 weeks to make this video. So... Okay. And I've had this judge a number of times before, and this is one of the very few judges that I've actually had positive experiences with. Not all of my experiences with her have been positive, but some positive experiences are better than none. So without further ado, here we go. This is September 5th, 2019. Prosecutor Nicholas Barber has got some explaining to do about all the disclosure that he's been withholding for almost a year now. Or does he? Let's find out. Here it goes.
Calling number 1 from Your Honor's adult list, the matter of Dan.
Okay.
Good morning, Judge Mrozinski. Judges really hate it when you say their name in court.
Yes. Good morning, Your Honor. It's Nicholas Barber for the Crown on the telephone.
I'm Dan.
Dan.
Good morning.
What's your first name? Dan?
Dan.
Dan. Okay.
Yeah. Good morning, Judge Mrozinski.
Okay. Good morning. All right. So what's happening today?
Thank you, Your Honor. We've asked for a pre-trial conference ahead of the scheduled trial date just to deal with a couple of outstanding matters, or at least in the Crown's respectful submission, some outstanding matters. And I could just list those off for you if you wish.
That would be good because I don't know what they are, so yes.
Okay. So there was an issue with Dan not having all the disclosure that he wanted. I think that it has been remedied at this point. But we'd ask that Dan just indicate on the record whether that's correct or not. And then the second thing is that Dan had subpoenaed about 10 police members from around the Colwood, Victoria area.
This is not true. I did not subpoena 10 police members from all over the Colwood, Victoria area.
For the trial, and those subpoenas now are no good, because we've switched the trial date, but I wanted to canvass with the court and Dan. Certainly, he is unrepresented. So we have no intention of trying to get in the way of his defense. However, I can't see why 10 police officers who were not involved with the current charge are relevant in any way to Dan's defense. That being said, there may be some reason, but what I'd like to avoid, if possible, is having 10 police officers sitting around for the day of trial and for no purpose or, you know?
Right. Ken, so I guess I have a sense from the charge what is alleged to have occurred. But can you just tell me so that I can determine or at least help Dan out with the relevance of those witnesses?
Yes, I think that's an excellent idea. So, Your Honor, the allegations are that Dan was videotaping outside of the detachment. Actually, what does the charge indicate?
This guy has no idea what he's doing.
The West Shore detachment is indicated there, Your Honor.
Okay. So he was videotaping?
Videotaping comings and goings of police officers and police.
So Mr. Barber is actually reading directly off of a false police narrative that was started in 2015, 2016. And he has no idea what he's talking about. He's just reading the script.
Police approached him and asked him what he was doing, and he refused to cooperate with them. And Dan is well known to the police, having caused various kinds of problems in the past at various detachments and members' homes and that sort of thing.
Causing problems at detachments and members' homes? I hope you got some dates on that. It's also worth noting, too, these 3 police officers that arrested me, they had no idea who I was. No idea until they forced me to ID myself. They had no idea who I was.
So there were concerns about what Dan's intentions were. He claims that he's part of a media company or media group, which is certainly not any kind of media that you would know.
I never claimed to be part of a media group or a media company. Never.
I think it's more his own, sort of civil social media, which is fine, but the problem for Dan is that because he's continually doing this, and on this specific date, July 25th, refused to identify himself or communicate, really, what he was doing and why it interfered with the detachment, both civilian and regular members.
Because I'm continuously doing this. And I've refused to communicate what I was doing and why. Can you imagine giving a courtesy notice about what you're doing, why, and how long you're going to be there and what you're going to be doing, and then they arrest you because you didn't communicate what you were doing there or why? Interfered with both civilian and regular members. Yeah, so remember that when you go there and you zoom in on your the most photogenic sign on the most publicly viewable side of their building. Remember that when you zoom in on that, you're interfering with civilian and regular members. So don't do that.
So we don't, as the Crown, just for Dan's sake, civil social media, citizen investigators of different public interest things is great.
Those citizen investigators are great. We could prosecute them and fill our time slot calendars with people to prosecute just because we got citizen investigators. It's great.
But you have to do it in a way that doesn't encroach on the lawful operation of, whether it's the police or something else.
Yeah, but you got to do it in a way that doesn't encroach on the lawful operation of whether it's police or something else.
Okay. So the Crown's witnesses are going to be presumably police or someone who saw this occurring, and they'll presumably identify Dan as the person doing it, and then it'll be a question of legal argument whether that constitutes the offense of obstruction or interference, contrary to Section 430 subsection 1 of the Criminal Code, and perhaps
Yes.
Dan will say it doesn't because it's free speech or something like that.
Yes, exactly.
Yes, exactly. We're prosecuting Dan for free speech. Yes, exactly.
And, Your Honor, because he's unrepresented, I want to avoid a whole bunch of members having to come off the street and sit around the court. That's one thing. But also, it would be good for Dan to speak to a lawyer because I don't think, strategically, if you just look at it that way, that any of that is going to help him.
Well, I'll speak to Dan, but...
Yes. Okay.
Okay. So what's your third issue?
Sorry, the third issue was...
So you talked about disclosure, and you need some confirmation that that's done. There's the subpoenas, which are not good now, but we'll talk about whether they're necessary or all of them are. And then I think you said you had 3 issues. But if you don't, that's fine.
I'll just double-check through this, Your Honor. Oh, there was. Yes, thank you, Your Honor. So there's an officer that we Corporal Kundu-Thomsen. This was set out in our original notice to adjourn the trial. Mr. or Corporal Kundu-Thomsen has been transferred to Ontario, and we are making an application that he testify by video.
Sure. Yes. And so what is his evidence going to be?
He's one of the primary witnesses who dealt with Dan outside of the detachment.
He's the primary witness. He's the sole complainant. He's the victim. He's the arresting officer. He's the guy that seized all 4 cameras and a cell phone. He's the guy that put this prosecution in motion. No other police officer ever said I had to identify myself or I'd be criminally prosecuted. Just him.
I think he was also perhaps civilly sued by Dan after the fact.
And now it's really odd that a prosecutor would bring up that he was perhaps civilly sued. That means that the prosecutor either is using their court computer system inappropriately, or the prosecutor or some prosecuting office or the police themselves are actually going through the proper channels and actually paying a fee to follow certain people's lawsuits. Because on this day, September 5th, 2019, I had not made that public, and I certainly didn't tell any of them about it. So it's odd that a prosecutor would mention that in a criminal proceeding.
Dan is, yes, rather.
So he's been transferred to Ontario. When did he get transferred?
Shortly after this incident, as I understand it.
Oh no, you don't understand it. Actually, you just lied. LinkedIn account, anyone? He was transferred a year after this incident, not shortly after.
So are you making that application today, or are you just notifying Dan that you're making that application?
Well, I'd like to make it today. Dan is there. It's been somewhat difficult getting these things lined up with him, and yes.
That's funny, you're right. It has been difficult getting things lined up with you when you don't respond to 4 letters.
I'd like to make that application today. If he wants more information or something else, I can certainly come back on another day.
Oh yeah, I'd like to come back on another day where I have to take another day off working and go for an entire work day unpaid. Yeah, I'd love to do that.
But I'd like to deal with that today if possible.
And when's the trial date?
I believe it's been rescheduled for March.
Okay, 2019 or 2020?
Hear this judge, she's like shook. This is the first time this judge has heard the calendar year 2020. She's like, March 2019? how can we? She's in shock. She's never heard 2020 before. That's how I know that they're just screwing with me. They made me wait 17 months for trial. Here we are, September 2019, and this judge is like, oh, what March 2019, 2020? She's in shock. Ain't never heard 2020 before. Guarantee you, this March 2020 date was the first thing scheduled for 2020 in that registry.
March 3rd, 2020, Your Honor.
March 3rd.
March 3rd, 2020. Okay. So we've got some time. All right.
We do.
Okay. Let me speak, then, to Mr.? Is that the issues, then, for the Crown?
Yes, but generally. There's other sort of collateral issues that I think will arise, but we can't probably deal with those today.
Sure. Well, let me ask Dan, then. Dan, please stand up, sir.
Thank you, Your Honor. For once, I mostly agree.
So you're dressed for court today, eh?
Yeah. It's hot out.
Not really, but okay.
Ever had the judge make fun of your clothes? So I was dressed for a hot day because it was a hot day. September 5th. It was a hot day. Judge makes fun of my clothes. Obviously trying to get a reaction out of me. Finally, for once, I mostly agree with Mr. Barber with everything you just said.
Let's talk about disclosure first.
Yeah. So I have some notes that I wrote. I just want to make sure I didn't leave out any details. So the majority of these notes are things like the policies that the prosecutor is not following, Canadian case law that the prosecutor is just completely in reckless disregard of. And I just want to warn this judge that I'm going to be referring to those.
Uh-huh. Well, I don't need a big length of notes.
Yeah.
The first question is, Dan, there was an issue around disclosure and
yes,
apparently you've had some disclosure. Can you confirm for me today whether there's any other disclosure that you need?
I haven't received the disclosure that I've been asking for since October 2018, which was almost 11 months from now.
So you cannot confirm today that you've received all the disclosure.
Not only have I not received it, Mr. Barber hasn't actually responded to my letters.
Okay, so you started out by saying that you agreed with Mr. Barber, but right away you don't agree with him.
Well, mostly.
Well, okay. So?
Mainly I agree with him about the time.
I'm going to run down. Oh, I don't know what you're talking about there, but I'll run down the disclosure thing. Mr. Barber, is that the case? You haven't responded with respect to request for disclosure.
That's absolutely untrue. We dealt with this on the last day as well.
Okay.
Notice how Mr. Barber doesn't have to answer the judge's direct question.
So Dan, what's the deal here?
So from the defense perspective on disclosure up to this point is that Mr. Barber has put me in an extremely difficult position
You're
here.
reading something. I'm just trying.
Yeah.
I don't need you to read something. I need to hear from you.
Okay.
What is it that you're missing? What is it that you say? Because,
yeah. So
it'll all get proven at the end of the day. So,
well,
all right.
Yeah, but if I can't speak, then you're not going to hear it. Okay, so...
Yes, you can speak, but not read.
Yeah, well...
No, you don't need to read.
Okay, that's fine. And this is where I was going to refer to the notes on their policy and eventually refer to notes on case law. And I'm not allowed to look at my notes. So it's funny because Mr. Barber has already referred to his notes. If you ever go to court, you'll see pretty much every lawyer in court refer to their notes and read from their notes. And I'm not allowed to look at my notes or read them. Luckily for me, I don't need to rely on notes. So on the first appearance, October 2018, I provided Mr. Barber with a letter of specific things that I asked for. The specific things that I asked for, as Mr. Barber detailed you earlier, was that I was videotaping. And that was the reasons for my arrest. I was videotaping.
Yes, okay.
So there was more than one camera recording, and there was also photographs and audio recording. I started recording this before the police approached me, and I recorded the entirety of the incident with the police. My statements, their statements, both of our actions. And it wasn't until the police arrested me and seized those devices and terminated those recordings and those that...
You mean terminated? By terminated, you mean ended the recording, stop the recording.
That's correct. So that specifically is my evidence that I have been very eagerly anticipating since the first appearance of October 2018.
So your videotape. You haven't got your videotape.
The devices were seized in July.
You haven't got the devices or the actual video.
Neither. The devices were seized on the date of my arrest, and I've sent Mr. Barber 4 letters.
No, but my question is, are you looking for the devices or the actual video?
Well, the devices, Mr. Barber says devices will not be returned.
Right.
But
I'm sure that's true.
yes, and I'm
Yes.
not asking for the devices. I'm asking for the video clips, the audio, the photographs. The devices were seized.
The actual things that you take.
That's correct. So those...
And you don't have those?
No, I've sent him 4 letters.
Mr. Barber, is that right?
So, Your Honor, I responded in writing almost immediately to Dan, and I won't read through the whole letter word for word, but what I told him was we do not have a warrant to search those devices. We cannot simply access them and copy them and give it to him. He needs to come to court and ask for that or put on the record that that's what he wants to have happen.
Yeah, that's really not how criminal procedure works. If the police catch you filming yourself murdering someone or assaulting someone or stealing something from a business, they'll seize those cameras because they afford evidence of the charges. And that's why they seized my cameras and cell phone. That's what they said in their statements. Those devices afford evidence of the charges. And so the police have to put in a warrant to detain those devices to be presented in court, which they have. And then they have to get another warrant to search those devices and download the clips and photographs and audio and everything. And then organize that to disclose to the accused, and then further organize it to use in a criminal trial for the prosecutor. And I pled not guilty about 11 months prior to this hearing. So they've had 11 months to get a warrant and get all their evidence together. And they haven't done a thing, not a thing, nothing at all. They're relying on me to come to court and waive my right to privacy and consent so that I can use my own evidence as an accused person in a criminal trial in order that I can prove myself innocent. That's what they're waiting to happen. They're waiting for me to do all this so I can prove I'm innocent, so I can actually use my own evidence at my own criminal trial as a self-represented accused. Let that sink in for a minute. That's what they're relying on.
Oh, why don't we just do that today?
That's fine. I have no problem with that. But this is the first time he's raised a complaint.
And of course the judge is like, oh, well, why don't we just, let's wrap that up today. Like, who cares he's not following his own policies and acting in accordance with Canadian case law? Who cares? Let's just wrap this up today. Oh, did you hear that? Mr. Barber just said this is the first time he's raised this complaint. So the first 4 letters, well, that was basically a complaint about not having the disclosure of the videos, right? And how about the previous hearing in front of the previous judge where I further made a complaint about not having the videos? How can this be the first time? This is really the 5th time. I've been asking for this material for almost a year now.
Okay. So, Dan, can we just tie this one up today so you can have those things?
I absolutely hope so.
So what, Mr. Barber, is the Crown requiring to issue from the mouth of Dan here today that would enable the Crown then to go? Please don't do that, Dan.
So I'm holding up the 4 letters that I wrote to Mr. Barber, and the judge wants nothing to do with it. Doesn't care.
So that would enable the Crown to go in and retrieve the video from those devices and give those to Dan, which he clearly needs?
Well, he needs to give us some kind of informed consent and request.
So here's what I suspected was going to happen. I talked about this in part 10. If you want to know more about this, go watch part 10 again, or that part of part 10, where we talk about me having to waive my right to privacy in order to get these videos. I won't go too much into it here, but that's what they're expecting me to do. That's what they're hoping I'm going to do. And then they can wash their hands of this and say, oh, no, we did the right thing. He didn't consent. So we didn't, then we dropped the charges. But I've been waiting well over a year now to face my accuser, and I'll let nothing stand in my way. It's kind of scary. I can just imagine somebody with no court experience going in and the prosecutor saying, oh, yeah, you can give some informed consent for this. And what kind of self-represented accused person is just going to walk in there and be like, oh, yeah, I got informed. Yeah, it was my lucky day. The prosecutor helped me out and told me what to say.
And if that's done verbally on the record, I think that's fine. But I will say, also on the record, that Dan wants, in my respectful opinion, confrontation with the police and the Crown. And
actually, what Dan wants is to go hiking and fishing on his weekends and have a good time. But since you guys dragged Dan into court, Dan doesn't have time for that anymore. So here we are.
So we need to just be very clear today that he's making this request out of his own volition in order to get this material for his defense, and it's not because of pressure or anything like that coming from the Crown or the police.
Oh yeah. This is I'm waiving my right to privacy, and I'm consenting to this. There's no pressure at all. No, I've only been asking for this for 11 months now. You guys have had my property for over a year now. Yeah, there's no pressure at all.
I'm just concerned at every step with Dan that things are done on the record and very detailed.
Okay. So, Dan, I only have half an hour for this. I've got to move along. So you're self-represented and that's a concern. Are you with Dan?
Yes.
Yeah.
Okay. Are you taping anything?
No, I'm definitely not.
And it's at this part where I turn around and I laugh. I snickered at my friend who is sitting in the audience there, Mr. Bruce Dean. He's got a YouTube channel called Photo Warrior Fundamental Freedom Fighter. And now the judge is grilling him.
No.
That's not allowed in here.
That's right.
Yeah. I don't know why you would think that I am.
So, Dan, the Crown doesn't have a warrant to search those items but you need that stuff.
I've asked.
And you, and that, and you want that stuff.
I've asked him already 4 times.
So can you say on the record here today, even though you're self-represented?
Yes.
Sir,
Yes.
I need very clear language from you.
Yes.
That you understand that the Crown, that you're asking for this, that the Crown does not have a warrant, and that you are authorizing the Crown and waiving any right to privacy with respect to what's on that stuff, right? Any right to privacy, and in which case, and you have authorized the Crown, then, to download from those items, the video camera and whatever else, the images that you've taken with respect to this alleged incident that occurred on around July 25th of 2018, bearing in mind that when the Crown goes in and downloads it, I don't know if there's something else on there, but it's going to see it. Do you understand all that?
I understand that, Your Honor.
Okay, so I need you to say what I've just said.
Okay.
All right?
So what I'm requesting for disclosure from the Crown is any video clips that were recorded on July 25th, 2018 from the 4 cameras that were seized by Corporal Kundu-Thomsen of the West Shore RCMP.
Okay. And you understand that you're waiving any privacy right that you may have to the contents of those devices?
I understood that in the first 4 letters that I asked.
I know you understand that. But I need you to say that. I need you to say positively that you waive your right to privacy.
I understand that I waive my right to privacy with respect to the videos being downloaded by the RCMP or Crown.
Because you want that material.
I've been waiting since October 2018, Your Honor. Very eagerly.
Does that help you, Mr. Barber?
Yes, Your Honor.
Wait, does that help you, Mr. Barber? She said she was going to help me.
It seems that he is aware now at this point that it's not specific videos that will be downloaded. I don't think we have the capacity to sort of do it in that manner. The things are going to be opened up, they are going to be downloaded, and they are going to be reviewed. We'll disclose whatever is on them, and if he's comfortable with that, then I think we can move forward with that.
And you'll confirm you're comfortable with that.
I'm comfortable. I've been comfortable for 11 months now.
Yes. Okay. Perfect. So we are going to deal with that. So that's going to be done. Can I get a date, maybe, for that to be done?
Oh, yes, Your Honor. I'll have that done. Well, I won't speak, maybe.
Well, he
but
told
for
the
at least
last judge he's given it to me already.
2, but in the next few weeks.
So let's say by, gosh, October 3rd at the latest. That's
Yes,
a
Your
month.
Honor. I'll get that on that right away.
Okay, so let's go on to the next issue, because I've only got 10 more minutes. So those subpoenas that you issued with respect
Yes.
to the 10 members, they're no good now.
That's correct.
You have to reinvigorate those. So, Dan, I wonder myself if they weren't there.
Well, that's the whole issue with this, Your Honor, is that from what I know, from what the police are relying on and the Crown is relying on, the bulk of the disclosure material, what little I've received, the bulk of the material consists of incidents that happened 4 years ago, 3 years ago, up until a month before my arrest. So all this material that's the bulk of the Crown's disclosure has absolutely nothing to do with this matter that I was arrested for on July 25th, 2018. And if that's the case that the Crown is going to put forward, then I'm going to have to answer full defense. And I'm going to have to rely on the police, the related material police members that are detailed in the bulk of the disclosure.
All right. So, interesting, Mr. Barber.
Yes.
So this video is getting a little long. We're only halfway through this hearing, so I'm going to have to make this a two-parter. This video took me about 2.5 weekends to make, so don't expect a video next week if you're watching this on the premiere. But do expect part 2 sometime in March 2021. And leave a comment below on how you think Nicholas Barber is handling this criminal prosecution. And leave a comment on how you think Judge Lisa Merznowski is handling this hearing. Leave a comment below and let me know what you think. Thanks for watching.